Welcome everyone, and thank you for joining today's webinar, You and the MREC Don't Get Caught Slipping Up, as we cover essential information on defending MREC claims. Jamal J. Stafford, Esquire, managing attorney with the law firm of J.W. Stafford, LLC, will share his knowledge and experience counseling clients in matters before the commission. Debbie Bindeman, Senior Account Executive, East Region for Pearl Insurance, will discuss risk management issues and the use of E&O insurance to address those risks. Together with moderator Kathleen D'Artes, Director of Legal Affairs for Maryland Realtors, our panelists will discuss best practices to avoid claims and strategies for defending claims. Kathleen, take it away. And real quick, as always, we encourage your questions. At the bottom of your screen, you will see a Q&A box. We encourage you to place your questions there, where they will be answered at an appropriate time. And
all right.
Kathleen, everyone, thank you.
Great. Thank you, Melissa. And thank you everyone for joining us on this webinar. Don't get caught slipping up, and you and the Real Estate Commission may not be the most glamorous topic, but it is important. And we are fortunate to have two experts here with us today as our panelists to give us some good information. Debbie Bindeman, Melissa introduced her briefly. Debbie Bindeman is with Pearl Insurance, has been with Pearl Insurance as an account executive and a senior regional director. And Debbie does specializes in professional liability insurance for realtors, attorneys, architects. Basically, that's malpractice insurance. So Debbie's going to give us a little bit of background on that, just for informational purposes. Before Debbie got into the insurance side of it, the product side of it, she was on the legislative side of it. So she goes very deep in the insurance industry and understands a lot of the policy decisions and why some of the legislation and laws are put in place. So great experience. Debbie has a couple designations that are important for those in the insurance business. She is you'll see CPCU after her name. That is a Chartered Property Casualty Underwriter designation, and she is a member of their association, their organization, and is a past president and been very involved in leadership in that organization as well, and is also very involved in community service, of course. The Maryland Realtors, from our perspective, we love that Debbie's been very involved with Maryland Realtors for years as well. And many of you, if you've ever attended our annual conference, chances are you've seen Debbie. She's always been very involved with our conference committee and attends the conferences as well. Any of you are going to go to NAR's conference in Orlando, you're going to see Debbie there as well. So we're really delighted to have Debbie here with us this afternoon. And Jamal J. Stafford, as also, we are delighted to have Jay with us as well. Jay's an attorney, and Jay gives guidance and advice and represents businesses and entrepreneurs in DC and Maryland with respect to regulatory matters. Initially right out of law school at UVA. Right out of law school, Jay was a clerk for the chief judge on the Maryland Court of Appeals, which is the highest court in Maryland. I think that's a ballot question this year, whether that should be renamed. Wasn't that one of our ballot questions?
I think Supreme Court.
Yeah, if you haven't voted yet, think about that. Yeah. If you don't know off the top of your head that that's the highest court, maybe that's something you should think about when you're casting your ballot this year. So after that, Jay was a litigation attorney with DLA Piper, complex litigation, state court, federal court. Jay's basically been a litigator or in court his whole career. After that, he was down at the boutique litigation firm in New Orleans, and now has started, got that entrepreneurial spirit as well, started his own law firm and has been running his own firm since 2015, again, representing licensed professionals in DC and Maryland, and a variety of employment law matters, representing people with discrimination claims, wage and hour claims, policy and procedure manuals, employee manuals, all that good stuff. Jay's a great resource for all of that. So we are delighted to have both of them here. They both are experts and have gone into the weeds and deep on some of these topics we're going to talk about. I'm going to start. I have a little bit of a screen share here, everyone. It's not too much. Let me see. It is the slide deck, which is, let me see. Hopefully everybody can see this slideshow. Yes, everybody can see that?
Mm-hmm.
Okay,
Yep.
so here's our slide deck there. There's the king, right? The king's gonna left standing at the end, and hopefully everyone watching this, you will be the king standing at the end, and you will not be one of the pawns thrown down on the chessboard.
Yeah.
All right, so let's kind of start. Again, I don't know. This is something people don't really like talking about. If you've ever had a claim filed against you, it's certainly not a pleasant experience. But it is something that everyone should understand. I mean, for one, if it does happen, you have a claim filed against you, or if you're a broker or office manager, there's a claim filed against one of your agents, you need to know as a practical matter how to respond, how not to respond. But really a large part of what we're going to talk about today is sort of prevention. And hopefully we will end up with techniques and strategies so you do not end up having a claim filed against you. And we're going to give you some tips on that and some best practices really to avoid having claims filed against you, or even to be able to represent yourself and defend yourself, excuse me, not represent yourself, but to defend yourself properly if a claim is filed against you. Yeah. So why don't we start maybe with you, Debbie, if you want to provide sort of an overview. I know our audience today may be a variety of people. It could be licensees, salespersons. It could be brokers or office managers. And maybe someone who was just licensed last month. So you want to sort of start with the basics, just understanding what the E&O policy is. Could you maybe give us an overview of that?
Absolutely. Thank you. And thank you everybody for attending. This is so nice to be able to talk with people and have a chance to explain some of this information. So just in general, E&O, or errors and omissions, is what the E&O stands for, in case you didn't know. The overall view of this policy is it is for defense if you have a claim against you, and the general statement about it is this policy is meant for real estate services that you perform for others. Okay, so working with buyers, working with sellers, of course, and if you make, or it's alleged that you make, an error or an omission in the context of your discussion in these transactions as you're going through it, and somebody decides to sue you, that's what this policy is meant to do. It's meant to defend you for any errors or omissions or misrepresentation. And there's all kinds of, we'll talk about some different kinds of claims, but that's the general intent of E&O, or it's also called professional liability insurance. Okay, so having said that, there is a lot of additional coverages and sub limits and sub coverages, I guess, if you will, within this policy. And one of them that we're going to talk about a lot, Jay's going to mention, is disciplinary actions and going before the board, the real estate commission. So almost all E&O policies have some coverage for you to bring an attorney or to help you respond. Typically, as in our policy with Pearl and XL, our carrier, there's no deductible for that sub coverage. So if you have a board complaint against you, you should notify your broker, and you should definitely then contact your insurance carrier to see how much you have, engage their attorney to help you respond. And not only that, but we see, as a little sidetrack here, we see that sometimes when there are claims or when there's a board complaint, it possibly could be more than just a board complaint. So you should just always notify your insurance carrier as well, because there may be additional allegations that might trigger some other aspect of the policy. So don't just assume it's just a board complaint, you'll just take care of it. It can't hurt to notify of course, your broker owner, but notify your E&O carrier to see how we can help you too. I know also Kathleen wanted me to touch on a couple areas. It's hard to say, be comprehensive of this is covered, this is not covered. But just let me say, just generally, if you need a real estate license to do it, that's the type of real estate activity that's meant to be covered in a real estate E&O policy, okay? And then there is some give backs, if you will, in most E&O policies for you, the agents, to list and sell your own residential properties. But you really have to look at your policy and or ask your broker if they, they're for their guidance, and share the policy language if they want to. But you should double check, and if you're the brokers, make sure that your agents, the activities your agents are involved in, is actually covered under your policy, because most policies will cover an agent who wants to just simply list and sell their own residential properties, even an investment home. If they have a rental property, now they just want to list it and sell it. And likewise, our policy will cover that with a couple of caveats. Not usually, they're pretty simple. But the area that is a little outside of this is if agents are involved in their own construction and develop, buying up a property, renovating it, and then selling it quickly, obviously to make a profit. That activity, it may or may not be covered in your E&O policy. So you have to look at that, and we can cover that, but not every policy does. So again, you should just make sure that what you're doing is covered under your E&O policy. But to start with, one of our risk management tips, we always say the absolute best risk management tip with regard to an agent owned, your own transaction, is let another agent handle it. Let another agent be your listing agent, even if you've developed that property, or even if you want to sell your own home. It's not a bad idea to shift the risk to the other agent, because again, the E&O policy is meant to cover real estate activities you do for others. So if you have another agent representing you, it's a lot easier to defend if there's a claim.
Right.
So
good. Hey, Debbie, can I just ask you one question, just to kind of drill down a little bit on what you had mentioned? I know that, the broker is going to fill out their application every year to renew their policy. And I know that the insurance company wants to know a number of agents, number of transactions, volumes, et cetera, et cetera. If I'm the broker and my application says that we do not handle commercial transactions, period, we're 100% residential. One of my new agent who joined my brokerage a couple months ago has a friend who's got a commercial transaction, and they're thinking like, well, he's my best friend. I want to take care of him. I want to handle that transaction. I'm in a bunch of Facebook groups. I'm sure if I have any questions, I could just post it on Facebook, and one of my Facebook broker friends or Facebook Esquire will be able to help me, and I'll be able to get through this transaction. So let's talk about that scenario. If your broker says you only do residential and I'm going to engage in a commercial transaction, am I going to be covered under that E&O policy?
Well, the good news is most policies, including ours, cover commercial transactions, residential transactions, property management, appraisals. There's usually a variety of real estate activities that every policy covers, whether your company is doing it or not. But what I would want to say about that is it maybe a different aspect, again, risk management wise. If you're an agent who is mainly involved in residential, and now you get an opportunity to sell a commercial property or a piece of undeveloped land, I can tell you from our experience, we have seen a ton of claims when agents step outside their area of expertise, because of course there's differences in selling an undeveloped piece of property or commercial property versus selling a home. So I would say you can do it, but absolutely involve one of your other colleagues who has experience with commercial properties, or your broker. I'm not sure I'd rely on throwing it out there into the universe. I mean,
good answer. Let's not throw it out to the universe, everyone.
Only because we know, and these you broker owners out there and you agents, you're smart enough to know it's a completely different animal to sell an undeveloped piece of land versus a house, so again, you can do it. Most policies cover commercial activities, but as a risk management technique, you should have somebody help you and guide you so you don't make a mistake or an error or an omission.
Right. Or make a referral to somebody either. No shame in making referrals.
Oh,
Um,
yeah. Oh,
yeah.
yeah.
And then the other thing I just want to touch on briefly, Debbie, I know like agent-owned properties, we get questions on the legal hotline about that. And I know also from teaching broker supervision classes, sometimes that comes up. You know, the broker can have different policies about agent-owned property. You know, maybe you have to run it through the brokerage, maybe you don't. Those could be, you know, policies that your broker sets up. But are there any sort of common requirements that an agent would have to satisfy? I think
Yeah.
off the top of my
Yeah.
head, don't they have to use standardized forms? And there's a couple
Yeah.
sort of requirements that have to be in place.
There typically are usually 3 or 4 different requirements that I've seen in all the E&O policies I've looked at, and I've looked at all of our competitors' policies too, and in our policy as well. The most common thing is again, agent-owned transaction, if you are the agent, you're listing and selling your own home, our requirement for sure is use standard board-approved contracts, use a seller's disclosure, and that's what I've seen in almost every policy language. But now we know certain states have developed, like Virginia, I know even has a disclosure, like a one form, a disclaimer disclosure. If there's a state developed form, Excel, our carrier at least is pretty flexible about letting you use that. That's okay. But the language says a seller's disclosure. Okay.
Right.
And then the other piece typically is have a home inspection or have it waived in writing by the buyer. And then sometimes I've seen a waiting period. You know, when you own a property, sometimes you have to own that property at least 180 days. We don't have that. The other thing I've seen is home warranty. Some carriers require a home warranty be sold or waived in writing. So there's a couple different conditions typically, but just check your own E&O policy. But most of them are pretty simple, and they're good risk management techniques. Again, you know, it's all about helping you to avoid claims. So those are all good things to do.
That's good. That's good. Yeah, and just again, a practical advice for the broker: if you're writing your policy and procedure manual or updating your policy and procedure manual, you should either reach out to your E&O, your contact at your E&O carrier. You want to make sure that whatever is in your policy and procedure manual is consistent with what the requirements are in your E&O policy. And even more importantly, make sure you communicate that to your agent. So if they're going to sell property that they own, they know what the requirements are. They know they have to offer a home inspection or whatever those requirements might be. Because if you don't comply with those, I don't want to sound like I'm negative about insurance, Debbie. I certainly am not, but you know, sometimes insurance folks like to reject claims, so don't get caught slipping up, right?
That's all right. That's all right.
Okay. Actually, Debbie, did you want to go through maybe just some sort of that was great. That was a great overview of the E&O policy itself, but did you want to maybe kind of give a little quick insurance risk management 101, kind of go through what some tips and strategies are just in general, how this arena works, and then we can kind of go into more details as we work through the rest of it? Okay.
Yes, absolutely. So just going, you know, generically, risk management 101, there's typically 4 different areas of risk management. The first is avoidance. The second is transfer. The third is retain or retention. And the fourth piece is control. And so when we talk about avoiding, I mean, you know, obviously the best way to avoid claims is no transactions. Well, obviously you can't do that.
I don't know if that's the best method, but that's a method.
That's a method. But, you know, to incorporate perhaps some avoidance, as we just discussed a second ago, if your area of expertise is residential sales and you get an opportunity for something else, you may want to avoid the risk by passing that transaction off to one of your colleagues or incorporate their help, and you learn from the experience. But, you know, avoidance, it's an okay technique. It may not be the best for realtors, but transfer, that's an excellent risk management technique. So first of all, you're transferring a lot of your risk. When you have E&O insurance, you're transferring most of the risk to us. You pay us a premium to take on that risk. If you have a claim, you know, you may pay only your small deductible, and the carrier pays all the rest of it. So that's a great technique. But also you can use transfer in different ways. For example, transfer the risk back to your clients as much as you can. I know you want to help, but for example, if they're asking you questions about, say, school systems um, or you know, the crime rate in an area, so try to transfer that information to them by giving them the source of the information. And for example, saying, you know, here's the information to check the school to see if this if your neighborhood or this home that you're interested in goes to this high school that you want your kids to go to. Okay, so give them that information so they, and we'll get into that in a second too. But also transfer the risk to other professionals, because you're not a lawyer. You know, talk to Jay. You're not a lawyer. You're not a home inspector. You're not a tax advisor. You're not a mortgage lender. You're a realtor. So you have to watch what you say and transfer those activities, those questions to another professional. So it's basically transfer and shift the risk as much as you can off of you. And then retention. For example, it's like a deductible in insurance. You may not be able to avoid or completely transfer every aspect of a risk. So you have to retain a little bit of it and keep it. And then control, the fourth technique, that is what we're really mainly talking about throughout this whole discussion, is how do I control this little bit of risk that I have to keep because I can't avoid it and I can't completely transfer it away. So that's kind of the risk management strategy 101. If that.
All right, good. Thanks, Debbie. I think that kind of gives everybody a better understanding of just what the options are and sort of the playing field, I guess, essentially. I think, Jay, we had talked about this earlier. I think part of understanding, you know, how to control your risk and your liability and your exposure, you have basically, that sort of begins with understanding what your obligations are and, you know, fulfilling your obligations. Did you want to maybe talk about that a little bit, give sort of an overview of that?
Yeah, absolutely. And good afternoon, everybody. And thanks for having me. You know, in many respects, lawyers are very similar to realtors, right? You all sell properties, I sell cases in some respects, but there's also some other similarities. Look, the quickest way for me to lose my law license is to mishandle money, and that's also a quick way for you to get in trouble with the commission. And so, you know, one of the obligations you have is to handle the money properly. Right. And that starts by first promptly putting the money in escrow. One of the situations, and look, I know that a lot of brokers have policies and procedures, but, you know, this area is ripe for supervision, increased supervision from MREC in terms of broker supervision. You know, one of the situations, I was talking with a colleague of mine, you know, that happens quite regularly, but is usually not a problem until something happens, is when you're going to, you know, you've got a situation where the buyer's taking a picture of the earnest money deposit check. And, you know, look, one of the situations you can run into is, well, what happens if you don't collect the check and you have a situation where the buyer backs out? Things can get really messy. So look, first, you got to handle the money properly, and everything's usually fine until you get into a situation where a transaction doesn't close and things get pretty nasty. The good thing is the commission has laid out some pretty clear rules about what to do if there's a dispute regarding the funds. And, you know, look, you got to follow it. You need to document compliance with it. And so that's one obligation that you all have, and you know, we have similar obligations on our end. So you definitely want to make sure you comply with the guidance. You know, if there's a dispute regarding the disposition of the funds in escrow, I'll just run through it really quickly. You got 4 options really. One, you can hold the funds until you get a release from all the parties to the transaction. Second, you can file an interpleader action in the court. Folks don't like to do that, but sometimes you do. 3, you can wait until a party files suit and you get an order from the court telling you how to distribute the funds. And 4, you can comply with the notice provisions outlined and you make a good faith determination of where the money should go, provide written notice to all parties, give them a certain amount of time, 30 days, I believe, to respond. But make sure you are following those guidelines because, if you look on MREC's website, there's plenty of cases where real estate professionals have gotten in trouble because they didn't follow the regulations. Second issue, and I know Debbie's touched on this and she's going to touch on it more. Second issue is material facts, disclosing those, making sure that if you run into material facts, that it's clearly communicated to the other side. And I imagine, Debbie, I think I saw in your materials, the recommendation is get the buyer to sign it and acknowledge the fact that they've been told about these material facts, because, look, at the end of the day, the buyer's broker or buyer's real estate agent is not going to be the one that's going to file the complaint. Usually with MREC, it's going to be the buyer who's ticked off that they weren't allegedly informed of this material fact before they bought. So look, again, make sure you comply with that. If you run into material fact, get it in writing, get it signed by the buyer, and make sure you've clearly communicated it. Next obligation is, and this is something that I just wanted to touch on because it's such an unnecessary thing, and that is renewal applications. It's very easy to, let's say, overstate the continuing education that you might have received during the to qualify for renewal. And so you see a few cases with MREC where the licensee is getting fined because they said they did X number of continuing education, they didn't. It's just unnecessary. So just make sure that you're documenting material facts, make sure that you're paying attention to the details. Those renewal applications and the certification that's on there means something, and MREC is definitely keeping an eye on that. And 3, make sure you handle the money appropriately. Have procedures and policies in place, and brokers, make sure you can document the fact that you've followed up and enforced those procedures and policies in case MREC comes knocking.
Yeah. Those are all good points, Jay. And that honestly, those are sort of, I mean, I don't want to sound demeaning or anything, but those are really sort of no brainers. Those are basics. Yeah. That's very clear in the Brokers Act. Those are all required. The EMD, it has to be received, it has to be deposited. There's provisions about how it can be released, when it can be released, that Jay went through those. You may or may not be surprised to know how many calls we receive on the legal hotline where, despite that very clear guidance, sometimes the EMD was never collected. Someone may have scanned a copy of a check to the other party, to the other broker, but a copy of a check is not necessarily a check. We've had other calls where, again, it isn't until the transaction falls apart that the broker who is supposed to be holding the money will notify the other party, oh, well, you see what happened. The check was returned for insufficient funds and we never actually received that money. So I don't want to trivialize this because it happens a lot. And if you do go to the Real Estate Commission's website and look at some of the disciplinary actions, it happens regularly. I don't want to overstate that, but especially the deposit. If for some reason you're supposed to be holding the deposit, if the contract says that your brokerage is holding the deposit, you want to make sure that you're holding the deposit. If
Yeah.
the check is returned for some reason for insufficient funds, you as a broker, as a team leader, office manager, supervisor, as an agent responsible for your client's money, you want to make sure that you know that is escalated, that you know that your staff knows, hey, if this check is returned for insufficient funds or wire is dishonored, I can't just like go, oh, well, that's kind of bad luck, you know?
Yeah.
They need to
No.
escalate, and you need to try and work that out. And people have been disciplined also. I believe it may have been a broker, the buyer's broker, I think, was holding an EMD, and they never notified the listing side that the check had been returned for insufficient funds, and they were disciplined for that. So even though these things are sort of basic and routine, they certainly should not be overlooked. And as Jay rightly emphasized, especially with other people's money, that is a really high standard there that you're obligated to comply with. And the other one I think that's a little surprising to me is the CE requirements. You know, when you're renewing your license online, you have to certify that you've completed all of your CE hours. And I would just tell everybody, again, this is sort of a very silly mistake to make. All of the information is uploaded to the Real Estate Commission. They have records of what classes you've taken.
Yeah. Yeah.
You know, so they're going to catch you, right?
Yeah.
This is not how to teach you not how to get caught. I don't want anybody to think that's the point of this class, but that's a silly mistake. And generally, from what I've seen, Jay, correct me if I'm wrong, but I think that's a $1,500 mistake.
Yeah, that's about right. And it's unnecessary. I mean, it's totally unnecessary. I mean, nobody wants their name on the Real Estate Commission's website. Just make sure you're paying attention to the details there for sure. Absolutely.
Right. Good. And then I think that was good information. The only thing I wanted to just touch on just for a quick second is just remember the Maryland Realtors contract. I know you're a litigator. You jumped right to litigation, but just a reminder for everybody, the contract recommends or suggests or requires, I guess I should say, that the parties attempt mediation first. And we can have another webinar about that and talk about that for a long time, but that is the requirement that they at least attempt mediation. It may or may not work depending on the parties, but if it doesn't work, that's when they would end up in litigation. There was one question in the chat, Debbie, and I think you touched on it just briefly, but someone was asking for a little bit of clarification, just to swing back to Debbie's quickly. Sure. For agent-owned property, if the E&O policy requires a disclosure statement, I think everyone knows here in Maryland, we have a disclosure disclaimer. So if the agent did a disclaimer, would that be satisfactory to the E&O company?
No, I hate to tell you all, it's our language, our policy language, and I've seen other language says disclosure, because especially, and part of the reason is, even though you have a choice, disclaimer, disclosure, for an agent-owned transaction, we require a disclosure. And part of the reason for that is because we want to make sure you're disclosing everything you possibly know about that property, especially because you're selling it. It's your house. You probably lived in it, maybe, or it was an investment property. And we see it's more costly when we have an agent-owned transaction. It's harder to defend that claim because you don't have the benefit of saying, well, I had to rely on the seller. I disclosed everything I knew from what the seller told me. Well, you're the seller, you're the owner, you lived in it. So we want to see a disclosure so that it eliminates as much as possible the risk, that you'll have a claim. So that's part of the reason and part of the logic behind why most carriers want you to use a disclosure form.
Okay.
When you're
Thanks, Debbie. Thanks. That was a good question, anonymous attendee. So thanks for asking that. And Jay, let me just run this one by you. There was another question that was asked, a little bit of guidance when an EMD is not paid. The contract has basically, there could be an initial deposit and an additional deposit. So, and it says the deposit will be paid within X number of days. So the question is basically, if the contract says the EMD is to be made within X number of days, the buyer doesn't deliver the check, and then the buyer ghosts the agent. So what recourse would the seller have and the agent have? So I mean, this is not going to be, we can't answer everybody's legal questions, but just in general, if you're supposed to have the EMD, your client never delivered it and you're having difficulty getting in touch with your client, I'm not sure that there's a perfect answer, but what would be maybe some suggestions?
Well, you certainly definitely want to let the other side know. All right.
Right.
That's number one. You know, I guess you certainly would want to, see if, to let the other side know. And I guess if they're okay with, if there's no sort of concern about who's going to, if they're not sort of saying, look, we're entitled to that EMD, I guess you're okay. But, I hate to say it, but, if you've got to, you may have to find yourself in a situation where you may have to look at a potential litigation if you have to, if they're the other side sort of saying we're entitled to that EMD. It just, I don't like it. I mean, maybe Debbie, I don't know if you ever had to deal with that. Is that something that they could turn to the insurance for to kind of cover that?
Probably
Well,
not.
yeah, the seller would probably, they'd have to start a claim and say, hey, you felt this deal's falling through, but you signed, maybe they've already signed a contract. We already purchased another house. We're moving out. We need that money. We need the sale to go through. I mean,
Right.
yeah, that could happen.
I think the answer to this, this is kind of the lawyerly answer that nobody likes, but I think the answer might be, it depends.
It depends. It depends. It all depends. Yeah.
Same thing.
All right. Well, let's keep to make sure we get through all of what we want to cover today. Let's kind of move on to the next area we were going to discuss. I think Debbie, maybe you were going to kind of talk about this from your perspective, from the E&O provider. What would you say are the most common claims that we're seeing now?
Yeah, and I'll tie those two next things together, kind of emerging trends and common claims, because they're tying together, and we'll kind of go through it a little quicker. Yes, I will tell you, first of all, good comment, Jay, about document, and disclose. Throw those risk management tips out there too. When in doubt, disclose. But most of our claims, here's one little quick statistic. About 3/4 of all of our claims are the buyer suing the seller and the listing agent. And if you think about it, it makes sense. Most claims are the buyer gets some property, and now they've got a problem, and they're going to allege that the seller was negligent in some way or didn't fully disclose the condition of that property. And they're going to sue the seller. They're going to sue the listing agent because they're going to say, you should have known, you represented that seller. Okay. So the majority of our claims are buyers suing sellers. So what that should say to you is, if you are an agent who works primarily with sellers, your risk of having a claim is a little bit higher. Okay. So just kind of know that. But the majority of our claims, the kind of claims we see most, are misrepresentation or failure to advise about something, and again, typically condition of the property. And that is about 75% of all of our claims is alleged misrepresentation. I mean,
That's
the other
high.
category,
it
is. That's the majority of our claims. And I will get into this in 1 second. It's probably the easiest to avoid, honestly, but it's the majority of our claims. And I'll tell you how to do that in a second. But the typical, there's typically, we sort of, for educational purposes, talk about it with regard to innocent, negligent, and fraudulent misrepresentation. And again, I'm not a lawyer, so Jay, feel free to comment too, and Kathleen too. But I think of innocence, or we think of innocence as when you simply step outside the bounds of your profession. As we mentioned, as a realtor, you're not a lawyer, you're not a tax advisor, you're not a home inspector. So if you're getting questions about the condition of the property, say, I see those cracks also. I recommend you get a home inspector to determine the extent of this damage, not say, oh yeah, that doesn't look so bad. And I know it sounds simplistic, but I can tell you, we get claims like that. So innocent. And also, here's another quick thought. Keep in mind that you might be working with a first-time home buyer. And by the way, we see more claims with first-time home buyers. And they've never done this before. They don't know what they don't know. Okay. And they're relying on you even more because you're the expert, you're the realtor. They typically are not going to double check what you say. They're relying on that information. So you have to be really aware of that and make sure that they understand all the terminology, the acronyms, everybody tends to use. Be simplistic with them and explain everything. But innocence, again, is if you step outside the bounds of your profession. Negligence is what we really see the most. And that is when you just don't use the proper standard of care to determine if the information you're giving your clients today, right this minute, is accurate. And again, things like school districts might have changed, and we've had horrible claims regarding things like that. For like I'll just tell you real quick, we've had a claim where the buyer told their agent, and this was a buyer's agent, that we want to get our kid into a certain high school. That's the main reason we're moving.
Wow.
And so the agent took them around, showed them all these properties, found a house in this great neighborhood. The agent had sold properties in that neighborhood in the past, did not double check to make sure that it was still that high school, did not shift the risk back to the client and say, you better check and make sure this address still goes to that high school. Nobody did that. So of course, where this is going. They proceeded with the closing. The buyer went to register their kid for high school, and it had been redistricted.
Oh.
And they sued their own agent, their own buyer's agent, for the cost of 4 years of private school education. And we paid it because it was complete negligent misrepresentation. So something like that is simple to avoid. And I'll tell you that in 1 second, 3-prong test. But one more quick comment about fraudulent or intentional misrepresentation. If you act fraudulently, either actively or passively, if you know something material in nature and you just think if you don't talk about it, it's not happening, not true, because that could be passive fraud. And fraud is not covered in E&O at all. You can't buy insurance to lie. So just know that. But let me go to this quickly, this 3-prong test, because we talk about, having a claim against you. And again, this would be the grounds to have a claim against you, is you say something, okay? You give information. And again, now 2nd prong, your client's relying on that information. They're not double checking it. You told them something. They relied on that information to make their decision. And now the 3rd prong is they're harmed or damaged, like that school example. Now they've got a house that it's not in the neighborhood or not in the school system they wanted. Those are grounds to sue you. So that's why we talk so much about shifting the risk and avoidance and watch what you say, because that's the piece that is so much in your control. You can avoid so many claims if you just don't innocently make comments or negligently make comments. So that's why I stress that so much. And again, that also sounds simplistic, but that's what we see.
Right. Debbie, I would just say, honestly, I know in the real world, you're a listing agent, you have to deal with a seller. And your seller, we all know this, the seller doesn't want you to disclose certain things. The seller thinks, oh, if I have to disclose that, the next buyer is not going to offer as much, or they're not going to want the house or whatever it is. So I understand there is some pressure there, maybe some resistance from your client. But the reality is that's your license. Your license requires it. So you have to be able to have that conversation with your seller and be able to explain to them why Jay could lead into this too, why it really is in their best interest to disclose it, because then they will not be sued by the buyer when that issue comes up. And one thing I've noticed, a couple of the real estate commission complaints, it's a little bit surprising to me. Well, we all know the neighbors talk.
Yep.
right? So the neighbor, your buyer moves in, and they all of a sudden they're having, there's heavy rainstorms, they're having problems with water in the basement. The neighbor's like, oh yeah, the seller's
All the
had,
time.
the waterproofing guy out 3 times, or
Yeah.
or the same contractor will come back to the house and say, we were
Yeah.
here 10 months ago and told the sellers to fix that. So a lot of these things that sound a little bit crazy, they do happen in the real world. So the listing agent, you can't, as Debbie said, you can't just pretend it's not so. It doesn't make it not so. It's a real thing. You sometimes do have to have difficult conversations, and it's difficult, but ultimately it protects you, and ultimately it protects your seller as well. Whether they realize that or not, it does protect them as well.
Yeah.
So those are really good points. Really good points.
I would almost say, I mean, you probably don't want to hear this either, but if you're realizing you're working with a seller that they just don't want you to tell anything, or hate to say this, discriminatory in any way, I only want my home to be sold to a certain group of people, or don't show my home to this group, walk away.
Yep.
I know it's money, I know it's commission, but I can tell you we've had claims where the poorest listing agents just dragged in because it's come to be determined that they're working with a discriminatory seller, or one who just doesn't want you to disclose everything. Or just, walk away. Say, I can't do that. I have, I go through your code of ethics and say, these are all the things I have to do as a realtor. If I can't work with you,
Right.
Yeah.
So.
All right. Did you want to maybe just touch just briefly on some of the emerging trends, or what we're starting to see now, just to give everybody who's viewing kind of a heads up on what they should be, maybe if you're a broker, maybe think about your policy or implementing a policy to kind of deal with some of these hot topics or emerging issues?
Yes, actually, let me go back to fair housing related. We are seeing an uptick again in fair housing related claims. Usually that's only about 2 or 3% of all of our claims. As I mentioned, the most of them are misrepresentation, but fair housing claims are more costly almost than any other type of claim. So if you even have a whiff that there's a fair housing issue, you really need to, if you're the agent, talk to your broker immediately. If you're the broker, talk to us, talk to your carrier right away, and because let us get in and get involved and find out what's going on, because fair housing claims are very expensive. You're on the defense in those kinds of claims. So there's that. And then one kind of sideline that I know Kathleen and we all talked about the other day was source of income.
Trying to pull that up. Where did it go? There it is. Can everybody see that?
Yes.
Yep.
We've had some issues, and you might actually have some more information too, Kathleen, but we all of a sudden too are seeing some source of income related discrimination in our claims with regard to fair housing. It's not just, race and religion and the 7 protected classes. It's kind of evolving a little bit into some other areas that are considered discriminatory. So just be aware of that.
Yeah, I wanted to pull this PDF, this document out just to make everybody aware of it. This is some guidance that was recently released by the Maryland Real Estate Commission. It's really good information on source of income, which I think all of you know, hopefully was added as a protected class here in Maryland, October of 2020. And there's some, some of the definitions up front, and then there are also some FAQs in here. And one thing just to point out, if you are a listing agent and you put in your remarks that you will not accept the seller will not accept VA buyers, no VA, no FHA, that is possibly discrimination on the basis of source of income here in Maryland. Different states may have different rules, but that is not permissible here in Maryland. If you need additional guidance, you could talk to the Maryland Commission on Civil Rights. But the Maryland Real Estate Commission prepared this document, which is a really good document that gives a lot of nuance and detail for source of income discrimination. And I did just want to touch on that. Everybody who's registered for this, we'll send you the handouts afterwards, so you'll get a copy of it. But again, that obviously is fair housing. You're violating the fair housing laws if you're discriminating against somebody. And again, just to hammer it home. If you are
Yeah.
putting no VA buyers, no FHA buyers on your listings on Bright MLS, you are potentially violating the law and potentially discriminating based on someone's source of income. So just be aware of that and really reach out to the Real Estate Commission. We'll share that with you. Make sure everybody in your office is aware of that as well, because that's relatively new guidance that may not have been as clear before, but now it is crystal clear. So that's a good one to be aware of. Thanks, Debbie, for mentioning that.
Yeah, the other quick thing I want to mention with regard to fair housing related is ADA compliancy. And we're seeing a rash of claims from us. There's a certain law firm that's been out there lately, a law firm from DC, we found out, that's going around checking individual agents' websites as well as companies' websites, looking for the visually impaired compliancy, or what the claim is, the allegation is your website is not ADA compliant for the visually impaired. And then they're sending them these notices and fines, and you have to pay X dollars or because you're not compliant. So if you get any of those kinds of letters or correspondence about your website, first of all, again, contact your carrier. We've been able to get rid of those claims pretty easily, honestly. And the other thing to know is if you are concerned about your compliancy, contact the NAR. They've got a lot of resources available to help you make sure your websites are ADA compliant. So we're seeing that.
You're a mind reader. I just was posting that link in the chat for people to
Okay.
look at.
Okay,
NAR has
good.
great resources on that. And we have a handout on that we'll send to everybody as well with some additional guidance on website compliance with the ADA.
Okay.
So that is a hot topic. The NAR is
that is.
discussing that at their seminars as well. So that is a very hot topic.
Yeah. And one more just 2-second thing, cyber related issues. We're seeing a lot of cyber related issues. And I'll just quickly say some policies have some coverage for cyber related wire transfer, data breach. We do. Check your policy, check with your carrier, because we're still seeing ransomware and wire transfer fraud, email hacking, data breaches, all of that. All the same thing that every industry is seeing, we're still seeing it with realtors too. So
let me ask a question. Actually, this could be either one of you could ask this. I know some brokerages, I mean, I know everybody's kind of aware of this, at least what the risks are. Some brokerages are now requiring the agents to use company emails, and you have to use the company system. You can't have everything forwarded to your, no disrespect to Google, but you can't have everything forwarded to your Gmail account or whatever. You have to use the company system. Are there any implications for the, E&O coverage for that, or Jay, maybe a litigation if it were to go down the road? If your company says you have to use our company's email system, it's encrypted, you have to use this. If someone doesn't, would that affect their coverage possibly?
Go ahead, Jay. I can answer that too.
You first on the coverage.
All right.
Yeah.
Well, I can tell you that we have an endorsement that we can add to our policy, our E&O policy, that it's meant to cover a specific email hacking scheme. I don't want to get bogged down in details, but our carrier has allowed the use of any email domain that a realtor uses for business purposes, but they prefer that you use the company email, and theoretically the companies have better firewalls and safeguards and encryption. It is a risk management technique. It's probably is best to use your company's email system, especially if they've got some good safeguards, but it all depends. You have to look at these policy languages. There's a lot of standalone policies that it's just like it's all over the board.
Right.
But
Okay.
generally, I would recommend using your company's website. Email domains. So that's my 2 cents.
Yeah. From a litigation standpoint, I would insist on company emails only, because as you know, and look, housing related litigation, this stuff can pop up years down the road, and you want to be able to take your attorney or whomever to one source for all the email exchanges back and forth. And if you have what I'll call this leakage where it's getting forwarded to Google, and the agents emailing the client from the Google email, from Gmail to outside of the company email. Like, there's a whole side of communications you're not seeing, and so I definitely would insist on. And then God forbid, what happens if, for instance, that Gmail account gets closed down? You can't get access to those communications. I'd absolutely insist on all communications, through the company's email server that's getting hopefully backed up 2 or 3 times a day. And, you can pull it 5 years down the road from now if you need to.
Right. I attended a seminar recently, and one of the attorneys said exactly what you just said, Jay. They, absolutely would really push to have people using the company email. And the woman who was doing the session said, honestly, she said, think about it. If someone's using their personal email for work, if they're in a lawsuit and there's discovery, theoretically, the other side could see all of your personal emails. Do you want to open up all of your personal emails to the other side?
Yeah.
If you're using your company email, they'll see your company emails, your work emails, not all of your emails. So I had not thought about that piece of it, but that's a good practical piece of advice, I think.
Very true.
All right. So let's keep moving forward, I guess, and we'll go back and hit on some of the questions as we have time. But I think let's just go chronologically, right? We've done everything we can. We're documenting everything carefully. We're following our policy, and the broker has put good policies and procedures in place consistent with our E&O policy. We're following our policies. We're documenting everything carefully. We're doing our best. And despite all of our best efforts, somehow a claim is filed against me with the Real Estate Commission. And I am sort of in a panic. And I just want to understand, this has never happened. I've been licensed for 30 years. This has never happened to me. What do I do, Jay? How does this work?
Yeah, well, no.
Walk us through that process?
Yeah, absolutely. And look, one of the things I first want to hit on is that feeling, like you mentioned, Kathleen, of panic, of anxiety. Look, the first thing you got to do is avoid panicking, right? Like, you got to avoid panicking. You got to understand too that the Real Estate Commission, like, look, these cases, they may be sending you a complaint, on something that happened a few years ago. And so, the first thing you've got to do is, one, don't panic, get in touch with your broker and get the carriers involved. That's the first thing, because the last thing you want to do is be responding to these complaints yourself. Right. I tell clients all the time, resist the urge to think that you can clear this up with a call to the commissioned investigator or something like that. I mean, I'm telling you, it happened. I can't tell you how many times, people, they feel like I can clear this up. It's just, I don't need to get other folks involved. Resist that temptation, and don't panic. The second thing is, and this is sort of a housekeeping issue. Look, you got to keep your address up to date with the commission. It's a thing that a lot of people lose sight of sometimes, but look, you need to keep your address up to date, because their obligation is to send correspondence to your address on file. Make sure it's the right address. You at least want to get the complaint. You want to make sure you've got an opportunity to respond to everything. So that's the second thing. Third thing, and this is where it comes back to, look, they're going to ask for a written response generally to the complaint. And so this is where that documentation is so important. And thinking about the documentation you create, look, you could have an issue with this transaction 2 or 3 or so years from now. And so you want to be careful. You want to make sure that the documentation you create is clear, that to the extent that there's certain things that, that need to be put in context, you kind of have that in there. Because look, I can barely remember what I did 2 months ago, but if you're being asked to think about something 2 or 3 years ago, you need to make sure you've outlined that context. And that's where, look, doing emails, clear emails, not text messages or, whatever they're using outside, like, you want to make sure your email communications are clear. And like Debbie mentioned earlier, look, a lot of times these complaints to the commission, that can be the first salvo. And so that's why it's absolutely important. You want to get counsel involved. You want counsel preparing the response, because look, once you get your written response in, that sets the table. The commission, the investigator, they've gotten the documents from the complainant, maybe have even talked to the complainant. So they kind of know what that side is. Once they get your written response, now the table's set. But now you may have to be prepared to wait. And this anxiety feeling, imagine that, you get your complaint January 1 of 2023, you file the written response. You may not hear anything from the commission for months or even a year or more. At that point, you've gone through month upon month upon month, sort of anxious, feeling like, look, the shoe's about to drop. And a lot of times folks get into issues where they start talking to colleagues about the issue. And you got to be real careful here. And I know it's a lot of stress. It's something maybe you've not dealt with before, but you want to make sure that you got counsel involved. You need to talk to somebody, talk to counsel, not your colleagues. Because look, the investigator could reach out to a colleague, or that colleague could run and tell the real estate commission something you said that could be harmful to you. So you got to control the anxiety. But like I said, you may file your written response with the commission, and it may be maybe months before you get an interview. Hopefully the case is dismissed, but let's assume it's not. It could be months or a year or more before you're sitting down for an interview. And so, look, we've got counsel involved. Important thing is we've got to take you from beginning to end of that transaction, refresh your memory, make sure you're solid about what happened, what didn't happen. And you got to prep for those things. Like, you do not just show up cold, show up just having sort of cursorily glanced over the documents. You got to make sure that when you're doing the interview, you are absolutely solid about what happened, what didn't happen. But that's where the documentation comes in. And that's why it's so important, because that documentation, that's all you're going to really have to remember what happened. And if it's not in writing, it's going to be a problem. So make sure that documentation's good. And look, just controlling the anxiety, because these investigations, we've got a client now, it's been 2 years since they got the complaint, and there's still no resolution. So just understand that that's the process. Get counsel involved as early as possible, and resist the temptation to try to do it yourself. So that's my little spiel.
Those are really good tips. And I sometimes say too, it is hard. It's really hard. Yeah. If you're an agent, you've been working with somebody, oftentimes you develop a friendship, or you certainly develop a relationship with them. And one thing I know that we talk about in some of our classes and our training sessions, if a complaint is filed, you really have to resist almost all of your natural instincts. Yep. You're going to want to apologize to your client. Oh, I'm sorry that happened. I'm sorry this. And if you're in litigation or an adversarial context, that could be used against you, that you're admitting you did something wrong. So it really is, Jay's exactly right on that. It's very difficult to do, but you do have to do this. You have to try and separate your emotions from it and just step back and look at it objectively. And like Jay said, if you have any questions or need to talk to anybody about it, talk to your broker or your office manager, or what do they say? CYA, call your attorney, right?
Call your attorney. We're psychologists as well. So
maybe some yoga, some meditation.
It's very important though. It really is, because
I agree.
You do not know who that investigator is calling. You don't know the person you're talking to. I've seen it happen where they call the commissioner of the board, in other professions. This stuff happens. So you got to be disciplined. You got to control the anxiety. If you need to talk to somebody, look, talk to your attorney. It's privileged. Privilege matters, and don't waive the privilege. Don't forward emails. Don't do anything that could waive the attorney-client privilege. I've seen this happen. Don't do it. But
I'm going to just throw in again social media. This
No,
is not a
please.
good idea to
No,
post these kinds of things on Facebook and ask for Facebook
Sure.
Esquire's advice.
No,
Because
No.
someone else could see that and again,
Yeah.
could share that. So
absolutely. And-
again, just be mindful of that as well. I know
Yeah.
we're kind of getting toward the end of our time here. We wanted to kind of finish up here with some best practices, some tips and suggestions. Again, we have a handout. Do you want me to pull that up, Debbie, or you just want to kind of give it a quick?
No, I'll just give you a quickie overview, but yes,
Okay.
we've developed some 12 risk management tips over all the years of 45 plus years, by the way, of writing E&O coverage with Pearl and 22 years of my experience as well, and a long, strong relationship with Maryland, Maryland Realtors. But probably of all those 12 risk management tips, you can probably tell from everything we've talked about, the couple of biggest things are watch what you say. Don't innocently make a statement that you shouldn't make. Again, shift the risk to other professionals, back to your clients, ideally. And if you don't know the answer to something, don't be afraid to say, I don't know. Let me look into it. Let me document where I got the information, as Jay said, and I'll mention that too. But just that kind of discipline of documenting your sources when you were asked questions, maybe email back to your client and say, here's the information I found. Just want to make sure you understand. Ideally, get your client to respond back to you, print out that email or save it into your files, and document. That's probably the biggest risk management tip we can stress. And as Jay mentioned about time frames for claims coming in, we know from our experience, typically a claim might come in usually within the first year or two after a transaction. So the nature of professional liability is it's actually covering the past, and it covers a company's all the transactions they've ever done. Now, whether that agent is still here today when that claim comes in, that can be an issue too. And that's why we stress document that file that stays with the company, especially because now you're not available, and today there's a claim and the poor broker owner has to defend it, and all he's got is that file, and if you didn't document it well enough, he's in trouble. So, and plus the fact, as we discussed, you may not be able to exactly remember what you said, and if you don't have any good documentation and it's he said, she said, and you're the professional and this is the claimant, you lose. Because you should have known better than to document. So the courts typically, right, Jay, they always fine for that claimant. If there's nothing, yeah. So that's why documentation is so important, and we stress that a lot in all of this. But that's probably the biggest takeaway, I would say. And also, I've heard some of our attorneys even say, our defense counsel say, just think of every transaction you're involved in could turn into a claim. You never know. So you should just contemporaneously make notes, document that file with the off chance that, you never know. Some months down the road, something could come back to bite you. So you might as well be prepared now, so you don't have to recreate and take time. And you were talking about the length of time of the board complaints. Our average length of time to close and settle a claim is about 1.5 years. So it does drag on and it weighs on you. And in the meantime, you're still trying to make a living, but yet you're dealing with this emotional and maybe having to take time and go dig for your notes. So just do it in the moment and it's done.
That's our legal hotline too. We always are recommending the confirmatory email. If you had a telephone conversation with your client and discuss something, I can think of one example that maybe more so last year, but with the market, it was a seller's market, very little inventory, right? A lot of buyers were waiving their right to have a home inspection performed. If I'm a buyer's agent, I want to have it documented that I explained to the buyer that you can do a home inspection. The buyer chose not to have a home inspection. The buyer
Yeah.
instructed me to submit an offer without requesting inspections. That is something I definitely would want to have in writing, because
Yep.
I don't want to be negative or anything, but let's suppose the buyer moves in and then there's a problem with the house. If it's
Yep.
not documented, the buyer could, well, I wish you had told me, I would have had a home inspection done, so
Right.
you want to be careful. You explained it and your client made a choice. Your client gave you instruction. That was a pretty common situation, probably more so last year than this year, but a very good example of something that you would want to document just to protect you down the road.
Yeah.
Absolutely.
Yeah. Let's see, I think we have, if everybody's okay, our time is technically up, but we have some questions. If everybody wants to, well, if you can't stay on the call, on the session, thank you for joining us. And I understand, time commitments, you have to jump off. But if everybody's okay, Debbie and Jay, are you okay with staying on for a couple minutes? We'll try and work through some of these questions.
Sure.
Okay. Melissa, help me if I miss any of these too. I'll just go through a couple of these. What is this one? Can you talk about a listing agent who, with a disclosed contract, for a customer, non-buyer client, and the risk that poses? I'm sorry. So here in Maryland, if the listing agent represents the seller, the buyer is unrepresented. The listing agent is going to help the buyer, fill out the contract. I guess either one of you, do you see any risks there, or any things the listing agent should be particularly careful about? I'll start with one. You need to make sure that you give that buyer the understanding whom real estate agents represent form, and have them sign it, showing that they know that you represent the seller. That's the first thing I'll throw in. Now you two can go ahead.
Well, I think Debbie touched on this earlier with the Ds, right? The decide, disclose. And so I would be, I know in terms of just the legal profession, with us, I mean, look, we've got to be very careful with unrepresented opposing parties. And I'm same thing in the real estate realm, I'm sure. But Debbie, I'm always reluctant.
I guess I would also agree that it's very difficult to have it be, I guess, fair, maybe, because it's hard. I'm thinking in my head about dual agency, even though this may not be technically dual agency because they're unrepresented really, but I would probably not help them. I would maybe say, look, can I get another agent in my office to represent you and help you as the buyer's agent? And then you've got somebody working with the buyer and the sellers. It probably should be. But I will also say to you all that at least our E&O policy doesn't preclude or doesn't not cover dual agency. It does cover it. I should say it that way. We don't like it. We prefer that you don't do it, meaning, one agent is representing both buyer and seller, because it's just an inherent conflict of interest, I think.
Oh, yeah.
So,
we can't do that here in Maryland.
Well, some states still can, I guess.
Virginia, I think Virginia, they call it designated, but I think just going to chime in, I think again, I'm going to give the lawyerly "it depends" answer. I think if the buyer, maybe it's an experienced buyer, maybe it's an investor, someone who's purchased a bunch of properties and they really just need help filling in the forms, I think that's one thing. If it's a first-time home buyer who's asking a lot of questions, should I do this? Should I do that? That's crossing the line. You cannot do that if you're representing the seller. So that's where I would say Debbie's right. Refer them to someone who can represent them in that capacity, because you would be stepping over a line if you were to give that type of guidance. You owe a fiduciary duty to the seller. All of your guidance, your judgment, your best recommendations, all that is owed to the seller. So if the buyer's asking you questions that step over the line, you really should recommend that they get representation from somebody else. So that was a good question. What was that? Kendra McCourt's question. Okay. Oh no, Kendra McCourt has another question. This, Debbie, for you, with E&O claims, or you, Jay, as well. Does a lawsuit have to be filed for an agent to use it?
No.
The threat of litigation is triggered. That's the whole reason you get E&O, because
hopefully to avoid.
But if you get a threat or there's something that happens, like you want, the E&O is triggered because they want you to notify them as soon as
Yes.
possible, right?
Absolutely. I could clarify that. Absolutely. Any demand is verbal or written we consider it a claim. Somebody's saying you made a mistake, you need to take care of it. That's a claim, even if it's not filed, if you will. So and likewise, let me also stress that even if you get that hint or that, well, first of all, it's a claim. I mean, if somebody's demanding, it's a claim. Okay. But if you recognize that you made an error or an omission and nobody's suing you yet or demanding anything, you should still notify your carrier and just put them on notice. And I will just say, from our perspective, it doesn't go against you unless we actually have a claim and we have to start spending money with attorneys. But just putting all of those notices, giving a heads up to your carrier, is fulfilling your obligation to let your E&O carrier know that there's an issue, and just a heads up. And then if it does develop into a claim somewhere down the road, you fulfilled your obligation, because we've had instances where it wasn't, the carrier we weren't told when the agent first or the broker first became aware of the situation. And it was some months later, and now it's going to court. And we had this, and they called and said, oh, we're going to court now. Can you help us? And hate to say, it doesn't happen often, but we said, no, you should have told us. We could have avoided all of this, possibly going to court. So if you're in doubt, just call your carrier. We're very professional. We, we take an approach that we want to be proactive. So let us know. Okay.
Yeah, Debbie, that's, you had anticipated, that was the next question in the chat was, you're recommending that we notify the E&O carrier about possible claims. Won't that affect our premium?
It won't really affect the premium unless we've actually paid money out. Oh, I'm so sorry. I thought I turned my phone off. I apologize, you guys.
Okay.
It's only if we have to spend money. So that's because when you develop a premium, we look at how much money have you paid in with your premiums versus how much has the carrier paid out. So if they've never paid out anything, but yet, there's a whole bunch of incidents reported, that just tells us you're keeping us aware of the things that are going on. We're not spending any money. We're just staying in touch. And that's a good thing.
Debbie, that just reminded me, I used to work at a title company years ago, and I would always contact the title insurance underwriter to get, the green light to do something. Even when I knew the answer, I would always often reach out to the title insurance underwriter and, get approval, get something in writing. Yeah. And I apologize. I'm like, I must get on your nerves. I call you all the time. I ask you questions all the time. And he said, Kathleen, don't worry about it. We have two types of agents, the ones we talk to and the ones who have claims filed against them. So
got it.
All of us, we want to be the ones that we talk to, right? Talk to an attorney if it's appropriate, talk to your E&O carrier if it's appropriate. We don't want to be the ones who keep our mouth shut, keep our head in the sand, and then end up with a claim filed against us. Yeah. So that one has been answered. Let me go through a couple of these other ones. What if the seller did not give the information to the realtors about damage to the house? They actually painted over the mold and water damage. The house was inspected, did not find it. The buyer had significant damage 3 years later and had to have the bathroom gutted because of the hidden damage. What is their recourse? So in this case, the listing agent did not have knowledge about the defect. I guess the seller concealed it from the listing agent. It wasn't disclosed, and it was apparently not picked up during the home inspection. So the buyer now wants some recourse. And maybe Jay, you want to lead with this one? What recourse would that buyer have?
A lawsuit. I guess the question was, would that be a latent defect? But essentially I would, I'd pursue a lawsuit there. And, the listing agent might get caught up in that as well, just because, well, look, did the listing agent ask? Did he or she do what they needed to do to sort of inspect, just to get the information needed about the property? But yeah, I could see that being a lawsuit pretty clearly there.
Yeah.
I agree.
Again, that kind of goes back to the need to document things. If it is something, you know, Jake kind of touched on this, and we've all touched on it throughout the hour here. If you are the listing agent, you want to make sure that whatever you ask the seller is documented. Whatever information the seller tells you is documented. You know, if you asked, are there any water issues or any latent defects or anything like that, and the seller tells you no, if you've got that documented, you may be named in the lawsuit, but you probably will be able to be dismissed from it, or at least to defend yourself successfully, and wouldn't have any liability if you've got that documented. So that's another reason to document carefully what the communications between your client. And I know some of people get annoyed with the contract, why, or the listing agreement, the buyer listing agreement especially. Why are there so many initials in here? Why does the seller have to initial here?
That's
a lot of
rough.
that is one of those kind of things, you know, that you asked the seller and the seller said, no, this property is not subject to a ground rent. No, there are no deferred water and sewer charges on this property. So a lot of that stuff is, you know, just to document carefully something that could go south and could have a dollar amount attached to it. All right, so let's go through a couple more of these. Let me see. Melissa, if you want to jump in, you can. Oh, a squatter. Oh my goodness. If a listing agent has to have a squatter removed from the property, is that a material fact that needs to be disclosed?
Probably.
I mean, because and then, you know, you gotta, I would certainly.
I would too.
That could impact the title.
Yeah.
I mean,
yeah.
Eminent, well, I mean, it could be a problem. Yeah, I would definitely disclose. Yeah, I would definitely disclose.
I think the buyer's agent too, if you see that the property is occupied by someone other than the seller, you should ask questions. You know, who are these people? What's going to happen? Am I going to do an eviction and get them out? Is a seller going to do an eviction? You know, what's going to happen? All that sort of thing. So definitely should be disclosed. And, you know, even if you're on the buyer side, it was not disclosed, I would say you have an obligation to ask some questions, figure out what's going on to protect your buyer. What else do we have? VA conventional finance, typically that is something the property condition putting VA conventional FHA, typically that is referring to property condition completely unrelated to people. Yeah, that's I would just say let's you know, we'll share that guidance from the Real Estate Commission with everyone. And I know the Real Estate Commission participated in a webinar with Glendora Hughes, as the General Counsel for the Maryland Commission on Civil Rights. And it really is considered source of income, and discriminating against someone on their source of income is discrimination. It violates the fair housing laws. So there are potentially property condition issues as well. I can see that. I understand that. But the point is basically you should not be saying no VA, no FHA. That's considered discrimination. And I think this is something maybe we'll do another webinar on. I think sometimes there's a perception that, you know, that's going to be so difficult for the seller to comply with those requirements. And I'm not sure that's always true. So we might do another webinar on that, and maybe have some people on here who can give a little more guidance, because I think there's a perception that those are, you know, bad for a seller. And I'm not sure that's always the case, you know. All right, let's keep moving through some of these. What if the property will not, again, property condition with FHA, VA, I will skip that. Quite a few about property condition, FA and VHA. Maybe we have our next webinar topic. Thanks, everybody.
Thank you.
There's quite a few of those. Here's another one. If you had a complaint and you responded, how long do you need to wait to hear the outcome? Seems to take forever.
Well, I'll tell you, it does take, it generally takes forever. I mean, it's, you know, it's this tension, and we talk with clients, we say, look, there's value to being quiet and letting time go by, right? You know, there's value to not having the commission act quickly, because look, if there was something that happened, you know, they could, you know, suspend your license, reprimand. You don't want that to happen immediately. So there's some value to waiting. But I mean, in terms of how long you could have to wait, I mean, like I said, we have clients that, you know, it's been 2 years. And, you know, it just, you know, they sort of run the show there. I mean, you're not in control of the situation, which it's sort of an uncomfortable feeling, but it's just, it's a lot of times better just to wait as opposed to trying to urge them to act quickly, because sometimes that may not be in your best interest.
Right. what's that old saying? Oh, no news is good news.
Yeah, I did.
Maybe.
maybe.
Yes.
Yeah,
Yeah.
that's true. That's true.
This is a question, I think, will a recording of the webinar be posted on our YouTube channel? Yes, it will. So that will be available. It give us a couple days to get that done, but it will be posted on our YouTube channel. All of our webinars are. Would it be wise to carry, here's a general insurance question, Deb. Would it be wise to carry some type of umbrella policy in addition to your E&O if you're a realtor and or a team leader?
Well, let me just say, typically you can't buy an umbrella over, or that would cover your professional liability, okay? Because the E&O policy is what's meant to cover professional real estate services. However, you could buy an umbrella over your personal assets, you know, to protect your home and your auto. You know, you should probably talk to your personal insurance provider. They can probably help you with an umbrella. And a lot of people do that because we've also seen, if there's some really egregious allegations made against you, we've seen claims where the agent is sued not only as an agent and they sue the company, but they sue that agent personally and they go after their assets. So sure, it's not a bad idea if you feel like you need a personal umbrella to protect your own assets personally. And again, not a lawyer, but maybe create an LLC. Is that right? That helps shield some of your personal assets, but maybe not.
Yeah.
But as far as professional, yeah, sorry, I shouldn't have opened that can of worms.
No, but yeah.
But as far as professional liability, we don't sell anything. There really isn't anything you can buy just as an individual agent over your company's policy. That's what's meant to protect you.
Yeah.
All right. And let me go now. I think that was the end of one person had asked a question that was pretty detailed about there was some sort of threat made. I think that might be more than we should really probably talk about on this webinar. I did just, oops, wait a minute. Sorry, that's on the wrong. There, the last couple slides, I guess we had questions. I think we went through most of the questions. There were a lot on FHA, VA, and property conditions. So I now have a big light bulb over my head. That's a good topic for our next webinar. So thank you all for commenting on that. I did just want to make sure everyone is aware, if you have other questions that were not addressed today, you can always reach out to the legal hotline, Maryland Realtors. We do our legal hotline. We answer the phones, live calls, Monday, Wednesday, Friday, 10 to noon, and then 2 to 4. Or you can submit your questions online. I always say if you're the kind of person who wakes up at 2 o'clock in the morning, I usually throw James Beslity under the bus. if you're the kind of person who wakes up at 2 o'clock in the morning on a Saturday with a burning question, call James. No, I'm kidding. I don't really say that. But if you are the kind of person who wakes up with a question at 2 o'clock in the morning on a Saturday, you can go to the Maryland Realtor website. You can type in your question online, submit it, then hopefully get it off your chest and go back to sleep. Lalika Scott is our legal assistant, and she divvies up those questions the following business day, and we make every effort to respond within 48 hours. So that is one way you can get your questions answered. Another one is, like I said, Jay and Debbie both have agreed they'll answer questions after the webinar. So if you have any questions, legal questions specifically, I guess, to Jay, general questions, or questions specifically to Debbie, or potentially something could be asked to both of them. There's a lot of overlap in these areas. So that's their contact information. And I did mention, I think Melissa had mentioned and Dan had mentioned at the beginning, we are going to share, the video is being recorded. It'll be posted on our YouTube channel, and some of the documents that we referred to throughout the class and some of the ones that we brought up, we're going to share PDFs of those with everyone who attended the webinar. So you'll get a copy of this slide deck. You'll have Jay's contact information. You'll have Debbie's contact information, and you'll have each of those handouts that we discussed or referenced during the class. So I think, Melissa and Dan, I think that wraps it up. Anything we need to do before we close, other than thank our guests for joining us? I appreciate your time and your expertise, and thank you so much for sharing that with our members.
No, thank you. Thank you.
Absolutely.
Yeah, thank you to Jay and Debbie and Kathleen for an informative webinar, and we'll see you at the next webinar. Thanks again to everyone, and have a great day.
Great.
Thank
Take care, everybody.
Thank you.
Thanks.
Bye.
Bye-bye.
Bye-bye.